Fair use myth number 2. If they put it on the internet, they meant for people to be able to use it, read it, copy it, distribute it in whatever way they want to. That's just not true. Okay, Dan's going to talk about how copyright law works and what the rights are for copyright owners in just a moment. But what's really important for you to know is somebody puts something up in social media, posts it on YouTube, puts it on their website. Just because you can grab it does not mean they've given you permission to reuse it, to redistribute it, to incorporate it into your work. Filmmakers tell me this all the time, and I have to disabuse them of the notion. That doesn't mean that they may not give permission. They may readily agree. They may say on the website or the place that they've posted it that they're okay with it. They may use what's called Creative Commons. Many of you will know about that, and give permission that fits into one of Creative Commons's categories. But you cannot assume just because they posted it, it's automatically okay. Third fair use myth that I want to dispel right away. Giving credit to the copyright owner or disclaiming ownership of the material in your work does not solve all your problems. That does not guarantee a finding of fair use or secure you against a potential claim. It's useful to give credit in a fair use case. The absence of credit may definitely hurt you in a fair use case for reasons we'll talk about in a few minutes. Removal of a bug from off of a network video or some other identifying factor may be used against you by a clever plaintiff's lawyer. But just because you give credit or you disclaim ownership, that's not making it a fair use automatically. And then lastly, a fair use myth that you may actually like to hear about. It is not true that once you've asked for permission and been turned down, that you can't fair use something. There are any number of circumstances where I have supported fair use after a client has asked for permission from an original copyright owner and been denied. The best example is the one I already just sort of glanced over just now, which is copyright law is not about protecting reputation. Just because somebody doesn't like the film you're going to be making or the story you're going to be telling, and they turn you down if you ask for a license or permission to use their work, that does not mean that you don't still have a fair use argument under the test that's laid out by Congress and the case law that governs what a fair use is. So it is not true that you should always avoid asking if you can't take no for an answer. Really important thing for you to remember, and a myth that I hear at least as frequently as the others I mentioned before. So with the myths and truths and the shorthands out of the way, any questions, first of all, before Dan gets into a more substantive discussion of the law? Okay, Dan, you're up. Oh, I'm sorry.
Yeah, I was just going to ask, I'm actually doing a piece right now using a lot of archive news footage. I don't get a lot of headway with asking people for permission. I reach out and I end up being bounced around the newsroom and never getting a straight answer. Is there some sort of like limitation or statute of limitations on I made a really good faith effort to get it and I got no legitimate reply? I need to proceed with my project. I called, I emailed, and I never got a reply back. Does that factor into fair use?
Well, it doesn't explicitly factor into fair use, but it's the kind of good behavior and equitable behavior that I think a court could take into account that would help you if there's a dispute later on. But generally speaking, when we talk to clients, we will tell them that we're going to proceed with an independent fair use evaluation, and the fact that you asked and didn't get an answer certainly doesn't hurt you, and I think it helps because you tried to do the right thing. I mean, the truth is that in many circumstances in the real world, what's going to happen is before there's a lawsuit ever filed, you're going to hear from that newsroom that you've taken the clip from, and they're going to be complaining. And the easy answer for you at that point is to say, look, I tried to license it or get permission from you. I'll pay your standard license fee. Let's put this to bed. right? That's the easiest thing rather than hiring litigators and proceeding down a more hostile path. So I actually think that if you've asked and you haven't heard back, you are definitely in a better position than if you never asked in the first place.
And is there some sort of like statute of limitations? Like this footage is 35 years old.
There is a statute. I'll let Dan address that. Things do fall into the public domain after a certain number of years.
But not 35 years.
Definitely not 35 years.
It has to be 1925 or 23. Can't remember exactly, or older to be in the public domain. There's ways other things can fall into the public domain as well, if they're older works, but not 35 years. Hi everybody. Before I start, I guess I should mention, because I see there's a little red dot flashing at the top left, that this session is being recorded. So if that makes anybody uncomfortable, you're forewarned that that's what's happening. So great to see so many filmmakers here who are interested in this topic. It's a topic that we love to teach in the clinic because it's so interesting. There's, as Dale indicated, there's no bright line rules. There's no easy rules of thumb. Everything is treated on a case-by-case basis by looking at the copyright statute and the various facts that might underlie a particular filmmaker's use of a third-party copyrighted work. So what qualifies as fair use is something that does require grappling with the copyright statute, but there are certainly some tips or some hints that will help you along the way, and I'd like to share some of those. But before I do that, I think I'll go ahead and share screen, and hopefully this will work, so that we can get moving on some of these things. All right, hopefully you're seeing a slide which says fair use generally. Fair use is a exception or limitation on a copyright holder's monopoly. And what qualifies as fair use is case by case, as I mentioned, and it's guided by the principles in the Copyright Act, Section 107. And that states 4 factors that help you identify what is and isn't fair use. But before you get to the factors, it's also useful to look at the preamble to the statute. Preamble to Section 107 states, by way of example, that the use of a copyrighted work for purposes such as criticism, commentary, news reporting, and teaching is a fair use and is not an infringement. And that is a cause for celebration, or should be, for documentary filmmakers, especially those who are part of this festival, investigative journalism type of documentaries, because those are the kinds of documentaries, those are the kind of filmmakers who generally do use copyrighted works for purposes such as criticizing them, commenting on them, analyzing news footage and news reports, teaching. And therefore, we regard these kinds of documentaries as really the quintessential example of a work that qualifies for fair use. Some of these principles are further illuminated in a document that's a very useful document called the Documentary Filmmakers Statement of Best Practices in Fair Use. And that is a document that was developed by some copyright lawyers, as well as working in conjunction with documentary filmmakers to create a document which really has a lot of good examples and guidelines, I think, for filmmakers, as well as for folks like insurance companies who are going to give insurance to cover films. And it's extremely useful to find. We do have someone who has joined our webinar today, Patricia Ofterhide, who I'm told is one of the authors of or participants in creating the documentary Filmmaker Statement of Best Practices. So hopefully we'll hear from her as well as we go forward. But that's something you can Google, and that's freely available on the internet. And so please take a look at that. The factors themselves, there are 4 fair use factors in the statute. And I want to go over them and give you some idea of what they mean. The first factor is the purpose and character of the use. And that asks whether the underlying copyrighted work is being transformed in some way by the filmmaker, by the secondary user. In this case, we're talking about filmmakers. What is happening to the underlying work to change it in some way? Is it being transformed in purpose or in character? For example, let's look at purpose. There's a case called Red Label Music, which involves something called a song called the Super Bowl Shuffle. And for those of us of a certain age will remember the 1985 Chicago Bears, a Super Bowl champion. And during that season in 85, the Chicago Bears football team came up with the song Super Bowl Shuffle, and it's sort of a rap song, and they embarrassingly sang and danced their way through the song, and there was a famous music video and so forth. But it really marked this team. And a filmmaker was doing a documentary about what he considered to be the greatest pro football team of all time, the 1985 Chicago Bears. And you really can't tell that story without in some way invoking or referring to the Super Bowl Shuffle. So he used, or the filmmaker used several seconds of the song and then even more seconds of the video cut up in a certain way, but to tell the story about the impact that the song had on the Chicago Bears season, as well as the sociological impact that the team had on America, because the Super Bowl Shuffle did become sort of a phenomenon at the time. And so that was taking a creative work, a song and a music video, and using it for a different purpose, not just to entertain folks, but to tell a particular story in a certain way. And that transformed the purpose, and that was helpful in its fair use analysis when the filmmaker was sued by the copyright holder of the song. The character. How can a filmmaker change the character or transform the character of a work? So there's many examples. Certainly you can take a photograph, an image, and zoom in on a particular part, or take a newspaper article and bring out a particular passage from the article, or maybe the headline is highlighted. That's a transformation of the character of the work. Some filmmakers would take video footage, audio video footage, strip out the audio portion and use an interviewee's words over the top of that video to comment on what's happening in the video, or maybe have a narrator talk over the video. Or conversely, a filmmaker might take a news clip, just strip out the audio portion of that and run that over some original footage that they might be using or they might have filmed. Another possibility is just simply to take news stories and montage them together with other news stories. Instead of running a 30 or 40-second news clip from ABC News, they might use a little piece from ABC News, from CNN, etc. And that type of montaging changes the character of those underlying copyrighted works and does help support a fair use argument on the first factor. Second factor is the nature of the underlying copyrighted work, and that asks whether the work is more factual or creative. If a work is very factual in nature, such as a newspaper article or a news story, it's considered to have thinner copyright than a creative work such as a Hollywood movie or a song, which is going to have full copyright protection. But note that even a creative work can be used in a fashion that would support a fair use, even if it does have full copyright protection otherwise. An example of that would be the Super Bowl Shuffle, creative work, which was transformed and therefore a fair use. And the use there was as a historical guidepost, as a historical reference to tie it to the 1985 Chicago Bears. You might find a really beautifully framed photograph by a photojournalist of a particular historical event, and the filmmaker might be using that in order to help tell the story of that particular event, to indicate to have proof, essentially, that that historical event actually happened, and is using it for historical reasons, not for the beauty of the photograph, not for the creative aspects of it. So that's factor 2. What is the nature of the underlying copyrighted work and how is it used? Factor 3, the amount and substantiality of the portion that is used. And here we're talking about, was the use by the filmmaker quantitatively significant? How much of it was used? How many seconds, or if it was the entire photograph, the entire article, or whatever. And also whether the use was qualitatively substantial. We're looking at there whether a film really took more than was necessary or more than was reasonable of the underlying work in order to tell the story that they're telling. Or maybe perhaps did the filmmaker, even though the use may be not that long, if it's a piece of footage, but they took the heart of the creative work, is qualitatively substantial taking, that might be a problem. But that's actually a factor in whether or not the use is a fair use. And finally, factor 4, which some courts have held to be the most important factor, and that is the effect of the use on the actual or potential market for the underlying work. And even though some courts have said that is the most important factor, other courts have looked to factor 1, whether a work was transformed or not. But they actually go together, because to the extent a work, the underlying work was transformed, most courts have said that it's going to have less market impact on the original work. But for the factor 4, the effect of the potential market, courts will ask, did the secondary user, did the filmmaker usurp the value of the underlying work? Can the film be deemed a market substitute? Is it possible that someone would actually view the film and its incorporation of another work as a substitute for going back and viewing the original work? And also, did the filmmaker deprive the copyright holder of any ready licensing fees? So that a filmmaker who takes an image from Getty Images, or maybe takes some footage from Shutterstock or a similar type of service, is going to have a much tougher time making good fair use argument, because by just doing that taking without getting a license, you're depriving those entities of doing the very business they're set up to do, which is to license their work, their images, their footage to other people, including documentary filmmakers. And you compare that with the taking by a filmmaker of using an old family photo, or what we like to call amateur snapshots. Those don't have any ready market. It's not likely for the filmmaker, if they use that particular image, to have harmed the copyright or the copyright owner or its marketability of that particular photo in any significant way. So those are the 4 factors, and it's important to note that you don't have to have each of the 4 factors in your favor in order to make out a good fair use case. It's possible to have just 2 or 3 of the factors in your favor, but if you can make the argument that they're the most important factors, or they're the most weighty in the particular context in which you've used the underlying work, then you can still win a fair use case. So those are the things that I wanted to talk about. And I think I'll throw it back over to Dale to talk about the statement of best practices, and perhaps some other ways to analyze a particular use of an underlying work in order for it to be still to be considered fair use.
So I was about to talk about the statement of best practices, but you know, I'm wondering, Patricia, since you were so intimately involved in its development, can you talk just a little about how it was developed and what your intentions were in putting that together?
Sure. It's really kind of you guys to invite me in, but I just first want to say what wonderful work both of you are doing in helping filmmakers understand their opportunities under the law better. Peter Yassi and I worked with documentary filmmakers in 2004 because there was a whole argument among legal scholars that copyright was constraining creative work. And I basically said, that's weird because all my documentary filmmaker friends just do nothing but complain about having their stuff stolen. So where I don't see any constraints. And Peter Yassi and I decided that since he thought he was right, that we should just go do some actual research. And that's what we did. And we asked all these people about their problems with copyright. And they basically said, what problems with copyright? And we said, well, it seems like as documentary filmmakers, you might not be able to get access to some things. And they're like, well, no responsible documentary filmmaker would ever undertake a project where they couldn't get access. And we were like, really? Could you tell me about the projects that you can't undertake because you wouldn't get access? And the list was so long that when we published that research, people were just horrified at having their own experience reflected back to them, because they were being constrained from commenting on the basic culture that they lived in. And that led people to say, well, could you guys fix that for us? And what we had to come back to them and say is, nobody can fix this for you but you, because you're the only one who cares. Everybody else is fine. The lawyers collect payments. The broadcasters have lots of filmmakers to choose from. The insurance companies don't have to take any risk. There's nobody who's having a problem except you. And you think you have something to say. And so they said, fine, could you write us a code of best practices? And we were like, no, because we don't know where your acceptable limits are. The only strength in such a document would be that the whole field thinks the same way about it. So, right now you're the lunatic, and the broadcasters, the lawyers, and the insurers are the gatekeepers of the asylum. What you got to do is to say, no, I'm surrounded by an entire field that knows that whether or not we can practice this as best practices, this would be the best practice. And the reason we found that was such a strong argument is that all the filmmakers were copyright holders. None of them wanted anybody to steal their stuff. When they designed their own limitations on what was acceptable fair use, they were actually very well balanced between the free speech rights of an ordinary American citizen who's going to say anything, and including a documentary filmmaker, and a creator who does not want stuff stolen for the legitimate market. And that document ended up being extremely robust. And frankly, Peter Yassi and I did not believe that if we thought that creating such a code of best practices might be a good idea, but that it might not have a real effect. But what happened within 6 months was that an errors and omissions insurer, which had been made aware of the document, saw an opportunity to compete against its rivals by accepting the terms of that document. And there were only 4 errors and omissions insurance companies in the country. Right now there are 5. So when that one company stepped out, another company stepped out the same week. And the next month, the other 2 were like, oh, fair use, we've always insured for fair use. Yeah, of course it's a case by case thing, but yes, we always do that. And overnight, it became industry practice. It took them a lot longer to convince the filmmakers that was true. It was much easier to convince the insurers. And then it took around almost a decade later to convince the film teachers that it was true. But as you guys have been telling people, this is a vital part of copyright law. If you took fair use away from copyright law now, it would be unconstitutional. And there isn't a judge in, well, there are some judges who don't know that.
There are some.
But there isn't an appeals court judge who doesn't know that anymore. So I'm extremely proud of the field for hanging through that process. And I'm extremely grateful to lawyers like you for making people aware that this is not just a legal decoration. This is a fundamental right that people have, like the right to self-defense. And they don't sign their right of self-defense over to expert lawyers under certain rare circumstances. They know that they have it. They know that they have the right of free speech. And that's the umbrella under which this very ordinary right sits.
Well, that is a fascinating background in history, and we're all privileged to hear it, because while we've been applying the best practices statement for quite some time, and we use it very assertively on behalf of filmmakers, I didn't know some of that backstory. I did know that the insurance companies ended up being the one of the key movers. And by the way, for those of you who are filmmakers and talk about social impact from your work, you have just heard the story of somebody making an enormous social impact by pulling together a group to come up with a set of standards that is really quite reasonable. And I'm going to tell you about them in just a moment. But Patricia, thank you so much, because I think that what you and the people who contributed to the statement did was really change the landscape. I agree with you. Documentary filmmakers were afraid previously, and now we very assertively encourage filmmakers to use fair use when it is in fact truly fair, not only under the 4-factor test, but under the statement's approach, which I agree is quite balanced. And so thank you. Thank you for your work. Thank you to everybody who was involved in building that. And I encourage everyone to take advantage of the link that Patricia gave you, although you can find it on the web referenced, quite frequently. Read the guide. It's really terrific, and it will educate you enormously. And I will tell you, we use it in our class and in our clinic, which I'm going to tell you about in just a moment. Our clinic at UCLA Law is a pro bono clinic for documentary filmmakers. It's something that Dan and I started because of our love for documentaries, and also because we recognize that doc filmmakers don't have the money to hire fancy lawyers, particularly early in the process before you have distribution deals or full grants. But it's the time when you really want to be able to get answers. Can I use this? Can I build a scene around this? Do I have to reach out and get a license? And in many instances, we've been able to help filmmakers make good decisions early on, rather than what probably some of you have experienced, which is being told by a lawyer or an insurance company or your distributor at the last minute that they don't like your fair use claim, or they think you need to call and get a license or spend a fortune to get a license to something that early on you could have planned your film very differently. So I saw this a lot when I was at Frontline in the early days, and I realized that the community needed help. But we had a second purpose in mind, and that was we wanted to educate the next wave of media lawyers and copyright lawyers and people who can work on behalf of journalists and on behalf of documentary filmmakers. In fact, one of our students is here today, Chris Adler. Would you wave your hand? Chris has joined us to listen in. I'm glad he was able to make it. And our experience so far, we've been at this for about 3 years, is that working with the International Documentary Association, with Sundance, with Film Independent, and with others who come to us directly or through referrals, that we've helped an awful lot of filmmakers get their films done and get insurance, because every insurance company still requires a letter, a fair use opinion letter, to clear films if you're using third-party material without a license. And it's been really not only successful, but for Dan and I, and I'll speak for him, it's been a blast. And we've seen a lot of great films. We've helped a lot of great filmmakers, and we've trained, or hopefully started the training, for an awful lot of good young lawyers who are going to be continuing this work long after Dan and I, and Patricia, I'll speak for you, after all three of us have stopped being able to do this for you. With that, there was an interesting question before that tied in nicely to what Patricia was talking about, which was about educational uses of documentary films. And we don't often get asked by filmmakers, what they can do about situations where teachers or academic institutions have snatched their work and used it to excess. So I'm not sure I have a really clear answer to the question. And this came from Simon Ferry. Simon, I can't see you, but I know you're still there. Oh, Simone, I'm sorry, I misspoke. I misread actually, and then misspoke. Anyway, the educational market is obviously very important to documentary filmmakers, an important source of revenue. So, there is an expectation when a certain level of use is being made academically that educators will in fact license. Where that line is drawn, I think, is another one of these case-by-case bases. I mean, obviously, the size of the audience, the frequency of the use all factor into whether or not it's a fair use. We use short clips from films pretty frequently in our classes, but we're really careful not to use very much. And we've asked for permission in some cases from our clients to use bigger stretches. So I don't think there's real clear rules with respect to the protection of documentary filmmakers' work either. But there's a pretty good argument to be made, especially in a situation where it's a substantial component of your ultimate revenue and support for the film, that it's okay to reach out to those educators and say, I'm willing to license for a reasonable amount of money, and talk to them about negotiating something along those lines. There's no automatic right for educators, for example, to on a regular basis use an entire film to show to a class of 50 or 100 students. That seems to me to exceed what's a fair use. And that leads us to the statement. And I think that one of the things that's great about the statement is it does provide, while not a rule of thumb, a way to think about this question without having to ask the lawyers as you're starting to plan and think about your film or your work. And what the statement says is that there are two key questions, all of which fall under the umbrella, as Patricia said, of making sure that we're both encouraging the creation of new works, but also avoiding excessive economic harm to the original copyright owner. And here are the two questions, and I actually think there are three. The first question is, did the unlicensed use transform the material taken from the copyrighted work by using it for a different purpose than the original, or did it just repeat the work for the same intent and value as the original? Right, that's that transformative use test that Dan was referring to before. And frankly, the Supreme Court, which has not spoken on this issue of fair use in over 25 years, but did in the famous case involving Roy Orbison's song Pretty Woman and a remake by Two Live Crew that was a parody, the Supreme Court said transformative use is really the critical question in fair use. Was it a transformed use by the secondary user? And that's where the focus of the court should be. Now, I will give you a fair warning. You've probably heard in the news that the Supreme Court just had arguments in a case involving Oracle and Google. It's the first time that they've taken on a case that has squarely presented fair use since that Roy Orbison case I'm referring to. So the landscape may change. We just don't know what the Supreme Court's going to do with this case. But in that case, Google has made the argument that they borrowed things using fair use from Oracle's software, from their Java software, in fact, in building the Android operating system. And it's going to be very interesting to hear what the Supreme Court has to say about that. And to be perfectly honest, I'm a little worried because anything the Supreme Court says on the subject of fair use tends to get overstated and twisted up by litigators in lower courts. So we'll have to see what happens there. So transformative is the first question. Was it transformative? The second one, was the amount and nature of the material taken appropriate in light of the nature of the copyrighted work and of the use, right? this gets phrased in a lot of different ways, but I like the statement's phrasing. It was in an appropriate amount and nature. Uh, Sometimes you see courts say, did they take just enough, or did they take more than was necessary to make the point? But I think the right standard was in an appropriate amount. And I'll be honest, when I'm consulting with clients and they ask me what they can do to strengthen their fair use claim, one of the things that I always will talk about is you could use less, right? If you could use less and still make your point, then you probably ought to. That will strengthen our case. And I would like to be able to say with a straight face, or I'd like you to be able to testify someday if it comes to that, that you took less than you originally intended because you wanted to be as fair as possible. Which leads us to the third question, which is in the statement, but it's not stated as the same kind of question. And that is, did you behave with good manners, right? Fair use, those words mean something. Fair is, in fact, something that courts and parties will think about when they're evaluating secondary uses of copyrighted material. Did you behave fairly? Right? That's why I said before, asking, even if you don't get an answer, can sometimes be very helpful, right? We did the right thing, or we tried to do the right thing. I mean, we have a number of instances in the clinic where questions come up about incidental creative works, murals or street graffiti that appear incidentally in the background. Incidental uses generally are found to be fair use if they're truly incidental, but sometimes because they're so good, filmmakers will linger on the shot just a little, right? Because it's great art and it has real impact. So sometimes we will encourage clients to write to, if we can figure out who the artist was, not to ask to license necessarily, but to let them know about their project, what they're thinking about doing, and asking whether or not the artist would like to have credit and how they'd like to be credited in the film. And I will tell you that while some filmmakers have been reluctant to do that, we've had a lot of success, and our filmmakers have had a lot of success with getting really nice responses from those artists who write back and say, I'm thrilled to be part of your project, or I'm thrilled to receive a credit and to be getting this kind of exposure. Thank you so much for your good manners. So those are the three parts to the test that as I see the statement, as I read it all these years later, Patricia, and I hope I'm not polluting or misrepresenting what the statement says.
There was one caveat though in terms of asking, not so much for the mural situation, which I think Dale portrayed accurately in terms of, we're not asking for permission, we're saying, hey, you have an opportunity to be credited, how would you like to be credited? Which is, I think, a better framing. But in other instances, when you think someone might be willing to license things to you for your film, be prepared, you have to be prepared to take yes for an answer. So if you ask and they say, sure, and here's the fee, it's not going to help you to say, well, that's kind of like, I don't want to pay that, so I'm just going to use it anyways.
Yeah, no, I think that's right. Right. Don't ask if you can't take yes for an answer. Now, that doesn't mean if somebody comes back with an exorbitant non-market, fee that they're trying to charge you, either because they don't want you to get a license, or because they're punishing you, or because they're pigs. That's a different case. But Dan's right. If it's a market reasonable rate, at that point, generally, we will advise clients that they should pay it. Now, there's another category I want to talk about, and that's music, because when we think about fair use, the music industry is I consider a tremendous blocker for documentary films. The people who do licensing and are responsible for licensing in the recording industry do an excellent job in dealing with each other for the most part, but they're not terribly fair in my experience with documentary filmmakers, and They don't seem to have much of a favorable opinion of the use of fair use in documentary films. So there's always danger there. We have some colleagues, Dan and I, who have told clients that they're not clearing commercial music anymore for documentary films because it's just too dangerous and too difficult. And as I said before, all you have to do is get a nasty letter and it triggers all sorts of negative effects for you. So music is something to be really careful about. And we've had situations, without naming the film in particular, where we supported a client's use of music as a fair use, both because it was a parody, it was a small bit, and it really wasn't going to have any economic impact on the creators of the music. The insurance company wrote the insurance policy. They provided E&O insurance, but when it got to the distributor level, the distributor said, no, we're not taking this risk. And they made them take the music out of the film. So at multiple levels along the way, music is really difficult. And I guess all I would say is you have to be very careful using music and trying to fair use it. It's also very expensive if you try to license it. So most of our clients hire, and most of you probably know that contracting with a composer is probably the preferable route to go. Okay, it looks like there's some other questions. So let me take a second. Go ahead, Dan.
There's one question that was raised by two different filmmakers here.
Right.
That are similar. To what extent is it okay to use footage or images from social media, Instagram, Facebook, Twitch? Can you do so? Can you repost someone else's posts? Are there fair use issues that are helpful in this regard? I'm hoping Dale, you can answer this because I know there's been some recent claims, and I think even published, and maybe Patricia knows whether there's been something published on this, but I thought there was some litigation on taking images.
There's been various claims and threats, particularly with respect to photography that gets posted on social media posts. And I will say that there's been the development of a group of lawyers that I and at least some of my friends would refer to as copyright trolls, folks who will jump in and file lawsuits at the drop of a hat, even in what I would consider to be fair use situations, in order to threaten and scare defendants into paying either substantial sums in settlement or racking up a bunch of litigation costs. It's been terribly troublesome in this social media space because people will post photographs and then a news organization, a filmmaker, somebody will take that photograph and use it in illustrating a point. And even if they've used it completely fairly under the 4-factor test, if you get a nasty letter from a copyright troll, or one troll in particular, and I'm going to name him because he's become notorious, his name is Richard Leibowitz, and God forbid any of you run into him. He doesn't even send letters anymore. He just files lawsuits right off the bat and then uses the lawsuit as leverage to try to milk a big settlement. Now, the courts have sort of caught on to some of his worst practices, and I won't go into all of them. So he may disappear at some point, but there are others lined up behind him who have now learned from this and have figured out that there's ways to make money. Now, to step back, I mean, most social media posts are not highly creative. And copyright law does distinguish between, real creative works that have commercial value and those that do not. So somebody who just posts, their reaction to something that this politician or that politician said is probably not got licensable or copyright value of the sort that's going to scare you away or scare your lawyers away from you using it in your documentary film, right? Remember what the factors are. It's not just transformative use, which is the critical factor according to the Supreme Court, but there's also economic impact, right? You always have to go back and reconsider and think about what's the real purpose of copyright law? Copyright law is designed to encourage and provide incentive to creators to make sure that they get paid for their work, their sweat, their creative instincts and their creations. People who are posting on social media aren't doing it because they expect to make money from it, with their clever statements or their OMGs. But it all depends on what exactly it is that you're taking from their social media post. There may be other considerations, by the way, besides fair use that you need to think about. There may be libel implications. There may be certain types of privacy implications, although not very likely if they've posted on social media. So I guess that's a long answer for it depends. But most social media posts, I don't think have the kind of economic value that is likely to lead to a really good copyright claim or anybody being able to overcome fair use. But there are some circumstances, and photos are the ones that have been coming up most recently.
Particularly when they're taken by professional photographers.
Absolutely.
Who do make a business out of licensing, like celebrity images, for instance. That's where you can get into trouble. And certain celebrities have gotten into trouble for posting photos of themselves out in public. And the photographer pops up and says, hey, you didn't pay me. I'm selling that. I could sell that to the Star, to National Enquirer, whatever. You have to pay me. So there have been some problems.
By the way, I don't want anybody to think that I'm ragging on photographers. Photographers have it tough, and it's getting harder and harder for freelancers to make a living. So I understand them wanting to get paid what they think is fair value for their photos. It's these copyright troll lawyers who in some cases don't even really consult with the clients before they start sending letters off and filing lawsuits. And that's one of the reasons they get in trouble.
So Simone Ferry asked another question, which is how frequent are copyright lawsuits, including those that are frivolous? I think she was under the impression that they're not that common, but then she realized, well, actually, there's a lot of even frivolous lawsuits that are filed that people don't even hear about. I would say, in addition to lawsuits, there's just claims. And even if something is not formalized into an actual filing with the court, even a claim by a copyright owner can put a monkey wrench in your project. If the claim comes in and you're trying to get insurance, you don't have insurance yet, you'll have to reveal that claim in your application process, because there'll be a question in your E&O insurance application saying, are you aware of any claims, or has anybody made any threats, et cetera? So you have to reveal that. If it gets to a distributor, the distributor might back away, even if there is insurance. If there is insurance, you might just decide to pay it because it's going to be within your deductible. So even claims, whether merit, with merit or without, can be problematic from copyright plaintiffs.
Yeah, I wanted to clarify my question, if I may.
Oh, sure, absolutely.
So what I was under the impression for many years is, well, the chances are just so low that you just don't hear about lawsuits. But then a lawyer told me that, well, you don't hear about the ones that settled, because then the terms are sealed. And so it's actually much higher than you think it is. And that's what I'd like you to comment
That's
on.
absolutely true. In fact, many of the claims, as Dan was just alluding to, never get to a lawsuit, right? The most typical way that these issues will arise is that the copyright owner or their lawyer will reach out and in a letter and an email and a phone call and complain and say, wait a minute, you took my work or you took my client's work. And then a conversation begins. And in those circumstances, I mean, the best outcome is that you explain to them fair use and they back away. That happens sometimes. I had one not long ago where in fact a music company backed down on a notice of copyright infringement that had blocked the showing of a film on YouTube. But it took some real work, and we had a very, very strong fair use case in that instance. More often, you end up talking about some kind of license fee and settling for what you hope is a reasonable sum. In many instances, however, the people who are complaining will say, wait, I can't charge you my regular license fee because then there's no disincentive for you to steal from me again. That's their words, not mine. So they're going to ask for their license fee double or triple or or quadrupled, and then you're negotiating on the numbers. And Simone, you're correct. You would never hear about those kinds of claims unless somebody went running to the press about it, and it's not that interesting a story most of the time.
Or even they've been, actually as part of the agreement, been forced to be quiet.
Yeah, sometimes.
That's possible.
Sometimes. You're absolutely right about that.
So Pamela Yates had asked a question very early on. I want to make sure we doesn't get lost. And since I see her here, maybe she can elaborate on her question. But it was something to the effect of, especially during this moment of racial reckoning, how should filmmakers use material fairly, or how can they use material fairly and with fair use ethically? And clearly part of fair use is, as we've indicated, fairness. So if something seems unfair, then that may be problematic. But beyond that, maybe Pamela, if you could elaborate on what you're on that question.
I know that I have a whole section of a film I'm working on, and with COVID-19, not everybody can go out on the street and film, but there's a lot of crowdsourcing of material that's out there in Google Docs that are being shared. So we're really struggling to make sure that we know who to attribute the material to, but we're not always going to be able to find the person. So what about that, and what about using that?
Well, I was going to say fairness, right? So if you make an effort, a good faith effort, you're not trying to hide anything. You are, in fact, actually trying to figure out who these people are, whether to seek permission or give credit or whatever. And you can't figure it out. You're running into dead ends. It's probably okay, but depending on what it is, I don't know if it's a drawing or artistry or just words or whatever. Chances are that the actual value is probably not that high. But it's possible.
No, these would be like if you wanted to build a sequence about the police attacking demonstrators in over 100 cities in the United States. So it's actually, these people may have been filming for 3 hours and they have 10 amazing seconds. But when you put 10 amazing seconds from 100 people together, you have a really powerful visual representation of a trend.
Right.
So that's what we're grappling with. We're grappling with a new pool of resources that I think makes us think about fair use in an old way, but maybe there's some new considerations too. So thanks for that, Dan.
So I guess, Pamela, I would add that, to the extent that you're using them together, and you're commenting on what they're showing, that starts to sound like a very strong fair use, even putting aside the fact that you don't know who the source is. So, when you don't know who the source is, it sometimes gets referred to as an orphan work, or at Frontline, we refer to these as best efforts cases. And you're still going to apply the same kind of fair use analysis, but to the extent that you're using multiples in that way, in a montage or in combination, you really are transforming them and turning them into something different than what they originally were. You're also probably not having any economic impact on the creator. So this starts to sound like a very strong fair use to me. And then you add in the fact that you tried to find out who it was, but you couldn't, there was no way to do it. And it starts to sound like a very strong case.
Okay, thanks, Del. Yeah, thanks.
I see there's another question about expectations on what it will cost to get a fair use opinion letter. And then somebody answered with a very helpful answer about the cost of E&O insurance as well. I mean, the truth is, I can't answer on how much it costs to do a fair use opinion letter because we do ours pro bono. I can't say that we do everybody's, so we can't do every client that might want us to, but we try to do as many as we can. And as Christopher will tell you, we do lots. And because the students are really talented and they work very hard at it. And they do most of the work under Dan's and my supervision. And we have them work in 3-person teams. There are other pro bono sources out there, and I'd be happy to share with people other opportunities. It looks like the person who answered the question initially is that Josh also found a pro bono legal analysis, which is really great to hear. Josh, I don't know if you want to tell people who it was. I mean, as Dan is saying in the chat right now, what we're finding on the insurance side for E&O insurance, depending on the kind of film that's involved, we're seeing prices between $2,500 and $8,000 for E&O insurance. More expensive on the more heavy archive or more heavy or heavier investigative films. But occasionally the insurance companies get pretty competitive with each other, as Patricia was saying earlier. Josh, I see you're there. Can you tell us who your source was?
And I was at a conference, and I walked up. I was at a conference about journalism, and there was a lawyer from Ballard Spahr talking about drones. And I went up to him and told him about the documentary, and I asked him for direction, and he connected me with another lawyer who would be interested in taking it on pro bono, and kind of went through that process.
That's great. Well, and Ballard Spahr is terrific about doing pro bono work, but again, I'll speak for Dan on this one. There's only so much that any one group can do in terms of pro bono work, but we'd be happy to try to steer any of you in the direction of people who would do for either low cost or no cost opinion letters, particularly depending upon what kind of project it is and what kind of experience you've had in the past and what kind of track record of getting your films out. I see Patricia asked a really good question too, and I want to make sure that I don't overlook this. Insurance sounds on the surface like a panacea. It's not. Almost all the insurance policies, actually every insurance policy, just like our car insurance policies, has a deductible or a retention, it gets referred to as, and they tend to run between $10,000 and $25,000. And usually that's per occurrence, which means per claim. So that part, the filmmaker would be responsible for, not the insurance company if there's a claim. And that's one of the reasons why very frequently a filmmaker, when confronted with a claim or a potential claim, is going to say, okay, I'll pay the $2,000 license fee or exorbitant fee that you're asking for, because I don't want to spend $10,000 on lawyers before the insurance kicks in, or before the $25,000 limit kicks in. And also, prior claims may have an impact on what you pay for future policies, just like accidents can have an impact on the premiums you pay on your car insurance. So insurance is a terrific thing, and I don't want to talk it down. And in fact, many of the insurance companies are really wonderful in terms of the service they've provided and the financial support for investigative journalism. But $10,000 or $25,000 can be an awful lot of money, and especially given what the budgets on most of these films typically are. If I'm given the opportunity, and if clients talk to us about their budgets, I almost always urge them to put aside some kind of contingency for license claims or copyright claims, as part of their contingency budget, because it's not unusual for somebody to pop up, even in Pamela, your situation where somebody that you had no way of identifying before suddenly pops up and says, hey, that's my photo. And by the way, I've licensed it to AP in the past, for $500, and I think you should pay me the same. Any other questions that are out there?
I think we caught the major ones.
Okay. Thank you for a very stimulating conversation. Thank you, Patricia, for being here and telling us about your fine work. And thank you especially for the work. And thank all of you guys for the journalism and the films that you do. And, you know, this is the reason why Dan and I do this, is to make sure these stories get told. And it's really a joy for us. And so go forth, tell your stories, and if you need help, be in touch. Okay, we're easy to find.